to speak to you about this topic, which is, compared to some others, a very narrow topic of IP law, namely the protection of, not IP law, of privacy law, the protection of IP address, mostly from the perspective of EU law and Slovenian law as well. There have been some developments in this regard. Now, IP address in itself, it's a very technical piece of information. It's just a numerical identifier which is assigned to every device connected to the internet. So in the current IP version 6, this is the IP address consists of 128 bits in this hexadecimal form. So the second indent is the current version of the latest version of IP addresses. And the function of such a piece of data is that it defines the location of any device in the network, which allows the devices to recognize each other and to communicate with each other using the Internet Protocol. That's what the IP stands for. There are basically two kinds of IP addresses: static ones, which are permanently allocated to a specific device connected to the internet, and the dynamic ones, which are assigned to a device on a temporary basis. So each time the device connects to the internet, it will get a new IP address. These ones are clearly show is the general geolocation of the device, not of the user actually, but the location of the internet-connected device. But the exact address will of the user will usually only be known to the ISP, so the Internet Service Provider. So the geolocation is a very general one. This part of the city is what we can get from the IP address itself. However, it can be used to reveal much more than that about any internet user, because first of all, the ISP can keep logs of website visited by specific IP addresses. The employer can keep the logs of the website visited by their employees, and in this regard, the IP address is crucial. On the other hand, website owners may record and will typically record the IP addresses of the visitors to their website. And crucially, law enforcement is able to obtain this information wherever it is recorded. And through this collection of information of IP addresses, we can draw quite a precise picture of a specific user's interests and the use of the internet. So we can build user profiles reflecting their preferences and interests and so on. And tracking their specific activity, of course. So this is the reason why IP addresses are potentially a vulnerable piece of information as far as privacy is concerned. So if we're an internet user and we want to protect the privacy of our IP address, we have technological measures. We can use a virtual private network which will transmit our internet traffic through encrypted tunnels, or we can use an anonymous browser such as Tor, which will route the traffic through several IP addresses. Layers as in onion. But what we're interested in is the legal protection of IP address, of its privacy. And here we have two basic bases on which we can rely. One is the protection of personal data, the information privacy, and the other is communication privacy, which are, two bases in our constitutional documents on which individuals can rely. So let's look first at the IP address as personal data. The legal basis for this exists in all basic documents. The European Convention of Human Rights doesn't have a specific provision on the protection of personal data, but will protect that under the general provision on the protection of private and family life. Slovenian constitution, for example, has a special provision on the protection of personal data, but in theory this is also considered just one aspect of the general privacy right. In the European Union law, on the other hand, these are usually considered as two separate aspects, or more separate rights, the protection of privacy of one's private and family life, and the other one is the protection of personal data. But the basis to protect personal data exists in all three basic documents. Now, the definition of personal data is now contained in, at least in the EU and its countries, in the GDPR, General Data Protection Regulation, and it defines personal data as any information relating to an identified or identifiable natural person. And that word is crucial, identifiable. That is the person that can be identified directly or indirectly by reference to any identifier or other factors, and so on. I won't read the entire definition. What's important is that the introductory recitals also mention online identifiers provided by users' devices or applications, such as IP addresses or cookies or RFID tags. So IP address is expressly mentioned as a possible piece of personal data. So we know what the consequences are. The processing of personal data can only be performed on the basis of the consent of the data subject or on the basis of some other reason laid down by law. So I said it can be a personal information, but when is it? The European Court of Justice first pronounced on this issue in two cases, Scarlett Extended and later Digital Rights Ireland. And in both cases it just simply stated that IP addresses are protected personal data simply because they allow the users to be precisely identified. It didn't elaborate on the criteria. And that's mostly because in these two cases we had, for example, an ISP who had the information both on the IP addresses and on the persons who were using those addresses, so was able to identify the user of any IP address. Now, a more important case is the case Breyer versus Germany, where the same person did not control the information on the collected IP addresses and on their users. Namely, Mr. Breyer sued the German federal authorities because the government-owned websites collected IP addresses of their visitors, so his IP address as well. And the authorities said, yes, they said in their defense, we do collect IP addresses, but we don't know who the users are. They're anonymous for us, so we're not breaching personal data. Well, they didn't succeed with this argument. The Court of Justice of the EU held that the crucial element is whether it's not whether the same person holds all the information enabling the identification of the data subject. The crucial information, the crucial element is whether they're able to get that all that information together. So is the possibility to combine dynamic IP address with any additional data, a means likely reasonably to be used to identify the data subject. And the court said that this is not the case if the identification of the data subject is either prohibited or if it is practically impossible. But this standard is quite low. So under the Breyer ruling, it's very often the case that, particularly when the state is concerned, the state has the option to get the information of IP address users from ISPs, for example, that in those cases IP address will be considered personal data and protected accordingly. And this is pretty much what has been the position of the Slovenian Information Commissioner even before this ruling. In its advisory opinions, it had held that a dynamic IP address will be personal data when combined with information on the time it was assigned or the time of access to the network, and combined with ISP's data, we know who was the user of the IP address at that time. And on the other hand, a static IP address is always considered personal data under the Slovenian Information Commissioner's view, because an individual user can always be identified on its basis. Now, this is the data protection aspect. Now, let's look at the other aspect of privacy protection, the communication privacy. We said that an IP address is purely technical information required to establish online communication. So it's not the content of the information itself, just technical information closely related to the communication, which we refer to as metadata. Now, the communication privacy is again something that's protected in our Constitution, in the European Convention of Human Rights, and in the EU Charter. The older two documents out of those refer to letters and correspondence, but the case law has been clear about this, that this also protects the privacy of any mode of communication, including electronic communications. And it doesn't only protect personal, intimate communication, also professional, commercial communication can be considered private and is protected under this heading. The option to protect IP addresses under communication privacy is very important under the Slovenian constitutional law, because it has the constitution has a very high threshold for any legal interference with communication right. It can be only based on a court order. Even if the police wants to act, they need a court order. That can be only provided when expressly provided for by the law, and only when necessary for the cause of criminal proceedings or for national security reasons. So very narrow reasons. Now, the communication privacy is not defined in any secondary legislation, either on EU level or the national level. But as far as IP address is concerned, the e-privacy directive is quite important, which mentions that also traffic data must be protected in a similar way as what applies usually for personal data or for private information. So I won't read the details, but this is a good basis to see where we're moving. And the Slovenian Constitutional Court also confirmed in 2008 that the protection of communication privacy also covers metadata. It didn't speak about IP addresses at that time, but the argumentation, the reasoning can clearly be expanded to IP addresses as well. So the question is not whether an IP address can be considered under communication privacy. The question is what constitutes a waiver of IP address privacy. Namely, the regular courts in Slovenia have held in several cases that an IP address will not enjoy protection under communication privacy if its user has somehow disclosed the information voluntarily and so made it not private anymore. For example, by using peer-to-peer file sharing networks, the users of the networks are revealing their IP address to other users of the same network. Not their identities, but the IP address is publicly visible to any other user. And the courts have held, you've made your IP address visible, it's not private anymore. We don't have to care about the constitutional requirements for invasion into communication privacy. and a similar position was held when offensive comments were posted on a public online forum which displayed the user's IP addresses. But the situation evolved a bit in the case Benedict, which started before a criminal court in Slovenia and ended before the European Court of Human Rights. Namely, Mr. Benedict was sentenced for possessing and distributing child porn and was identified by the Slovenian police based on the IP address provided by the Swiss police, which obtained this address by monitoring the file-sharing network Razorback, in which IP addresses were visible to all its users. So all they had to do was monitor the network, and they got the IP addresses. Now the Slovenian courts, as well as the Supreme Court, held that in this case no intervention in internet traffic was conducted by the police because they only needed to monitor the exchanges in the network. So this was not private information, and the Constitutional Court confirmed that. They said that Mr. Benedict had consciously exposed his IP address to the public by using a public P2P network and had no legitimate expectation of privacy. However, the European Court of Human Rights disagreed. They said that it's true maybe that Mr. Benedict had no reasonable expectation of privacy of his IP address, but still had a reasonable expectation of privacy of his identity, which he did not reveal online, and was not directly identifiable. So he still enjoyed a quite high level of anonymity, regardless of the fact that the police was able to identify him. So in this case, the consequence of the ruling is that the interference with his privacy was illegal, and accordingly the Criminal Procedure Act was amended so that now court order is always required to obtain traffic data as well as to obtain subscription data where processing of traffic data is required to achieve that. Now, this requirement of processing of traffic data has turned out to be important because all these cases that we discussed, also the Benedict case, concerned dynamic IP addresses. In concerned dynamic IP addresses, we need some processing of traffic data to identify the user of the address. On the other hand, when we're dealing with a static IP address, the same one for the same user at all time, an ISP can identify the user simply by viewing their own records on the assigned IP addresses, so no processing of traffic data is required. So does this mean that there is no invasion of communication privacy and that the police will need no court order to get that information from the ISP? Now we have here two lines of case law. The appellate court in Ljubljana held that this is the case, that this is not an invasion of IP privacy, communication privacy when static IP addresses are concerned. The appellate court in Maribor, the second largest city in the country, held that an IP address will always be considered private information, regardless of whether it's dynamic or static. The Supreme Court hasn't ruled on that yet, but it seems from its statement in one of the recent judgments that they are leaning towards the Maribor statement, so that they said that there seem to be no valid reasons for a legal distinction between static and dynamic IP addresses as far as the privacy protection is concerned. It's the last slide. Just the conclusion, yes, we have learned that the IP address can be protected under both rules of personal data protection and the communication privacy. What's interesting is that this distinction between dynamic IP addresses and static IP addresses, the development of this case law brings us to the effect that there's a strict protection of dynamic IP addresses under communication privacy, and on the other hand, a stricter protection of static IP addresses under data protection rules. But it seems that we're moving in the direction where this distinction will become less relevant, and I think there's a growing awareness of the courts of the privacy implications of IP addresses and, of course, the possibilities of their abuse. So I think, although a very technical information, it's one that will increasingly be legally protected under both bases for the protection of privacy right. So, thank you for your attention.